Hey AP Government class, Mr. Sharon here. We're going to pick up with the next set of Supreme Court cases. So the next one we're going to talk about is New York Times versus United States. This was 1971. So a little bit of background about this case. This had to do with the Vietnam War. So the United States had been specifically involved in war against North Vietnam since 1965 by this point. So this case is 1971. We had been in a direct conflict with North Vietnam since 1965, and we had also been in conflict with the Viet Cong, which was a terrorist group in South Vietnam, for even longer than that, into the early 1960s. The whole point of the Vietnam War was to try to prevent the spread of communism. North Vietnam was being aided by the Soviet Union to try to take over South Vietnam, which was democratic, North Vietnam being communist. So we were trying to defend South Vietnam from falling under communist rule because at this point in our history, we're in the middle of a Cold War against the Soviet Union, and this idea of communism as a form of government, communism meaning the government has complete control over your life. You have very few rights and freedoms. The government controls all businesses. There's no free market. You don't have the right to open up your own business like you do in the United States, which we call capitalism in the United States because you have a lot of freedom to do what you want economically. So that's the backdrop of this. We have been fighting in the Vietnam War. So dating back to 1967, the Secretary of Defense wanted to compile this classified document, which ended up being 7,000 pages. It's supposed to be a top secret history of the U.S. involvement in Vietnam, dating all the way back to 1945. So it would cover 22 years of information of what the United States was doing in that region of the world. Well, after the report was published, one of the producers of the document, which this document became better known as the Pentagon Papers, once again, this is 7,000 pages long, so there's a lot of classified information there. One of the producers of the document leaked the information to a New York Times reporter. And in 1971, the New York Times started to publish articles about the classified information within this document. So immediately, Nixon's administration went to the court system, and a district court ordered the New York Times not to publish any more of these documents or any information about them. It's kind of a cease and desist order. So the newspapers argued that, and newspapers involved here being the New York Times and also the Washington Post as well, because they started to publish the same type of information, or at least they wanted to. They had access to it. The newspapers argued that the First Amendment freedom of the press prevents prior restraint. So prior restraint is really what we would consider the most extreme type of censorship. Usually censorship is when a government will take action against material after it's already been presented to the public, and then the government will do something to for lack of a better term, to censor it, to take away our access to it after we've already been exposed to it. Prior restraint, you don't even let information reach the public. Prior restraint is the government saying the public cannot know about this information at all. So this is very extreme, and based on First Amendment freedom of the press, a precedent was set where prior restraint, there's a heavy presumption against it, meaning based on the First Amendment, we do not believe that prior restraint is legal in the United States. So the key questions here are, can the government use prior restraint in cases involving national security, which was the argument by Nixon's administration, and also how far does the First Amendment freedom of the press extend? So just really quickly, the ruling in this one, I'll read it for you. The government is limited in its use of prior restraint, even in cases involving national security, based on First Amendment freedom of the press. So according to the court, the information was leaked. It was out there. The press already had it. The government could do nothing to stop the publishing of that. I mean, afterwards, the government could always try to sue the New York Times if it proved to be a danger to society that they leaked this information, but they could not prevent the information from being published since the New York Times already had their hands on it. Additionally, the court didn't see any inevitable, direct, and immediate harm to the safety of American forces as a result of this publication. So I'm sure that played a role. If there was information in there that the court viewed as an immediate threat that might lead to a revolution in the United States or the downfall of our government, their decision might have been different. But based on their interpretation of this 7,000-page document, they didn't think that anything in here would endanger society if it was published. The next case we're going to look at is Schenck versus United States. So the backdrop of this one is World War II. World War II had been being fought, and during the war, because we were underprepared, we only had 200,000 soldiers enlisted at the time we declared war in 1917. The United States had to resort to a military draft. And we know that this is always very unpopular when the government forces mainly young men to report for service, and there's always the potential that you're going to get shipped off to fight in a war you didn't sign up for and lose your life as a result. So during World War I, there were two members of the Socialist Party, Schenck being one of them, who distributed through the mail approximately 15,000 leaflets or pamphlets or flyers, whatever you want to call it. It was just a sheet of paper, and you can see some photocopies of those down in the bottom left-hand corner here, what they look like. So they mailed these out, approximately 15,000, to draft-aged men, urging them not to report for duty, with the idea that, hey, if everybody refuses to be drafted, if nobody shows up, what are they going to do? Put everybody in jail? They can't do that. The reason for this is Schenck cited the 13th Amendment, abolition of slavery. So he said this is no different than enslaving people. If you're forcing them to serve in the military and die against their will, well, that violates the 13th Amendment. A little more background here. At the time, there was a set of laws on record called the Espionage and Sedition Acts, which President Woodrow Wilson had pushed through Congress. And this made it illegal to publicly speak out against or interfere with the U.S. war effort in any way. So newspapers were not allowed to publish anything that was too negative about what the U.S. was doing at the time, because it was still kind of unpopular for the U.S. to be involved, simply because World War I was mainly a European conflict, and there were some people who didn't understand why the United States was going to start drafting young men to send them over to fight in what many viewed as Europe's problem, not our own. So the Espionage and Sedition Acts would silence any dissent. The key questions here were, did the Espionage and Sedition Acts violate the First Amendment? Because technically what Schenck was doing with these leaflets violated the Espionage and Sedition Acts. Did the leaflets distributed create a clear and present danger to the nation? So the ruling on this one is the Espionage and Sedition Acts did not violate the First Amendment, even though it severely limited freedom of speech and freedom of press rights. The court argued that during a time of war, the government needs more power to do their thing in order to preserve our safety and national security, even if constitutional rights are limited. So anytime there's a war, we see our constitutional rights be limited. It's understood that this is just what happens in wartime, that your constitutional rights are not the same during times of peace as they are during times of war. So they viewed the Espionage and Sedition Acts as necessary. Speech or expression that creates a clear and present danger to the nation is not protected by the First Amendment. So according to the court, what Schenck was doing with the leaflets, urging people not to report for military service, would lead us to a shortage of military personnel, which would cause us to lose a war, which could cause our collapse as a nation. So they viewed that action as a clear and present danger. This is when the Supreme Court came up with the famous example of shouting fire in a crowded theater as speech that is not protected by the First Amendment. So the court went a long way in Schenck versus the United States to kind of define, well, what is protected under the First Amendment? In that example, if you're in a crowded movie theater and there is no fire and you just want to be a wise guy and shout fire to cause mass panic, well, that could cause people to get hurt because of the panic, everyone rushing out, people tripping over each other. That would create a clear and present danger and would not be protected as free speech under the First Amendment. The next case, Gideon versus Wainwright, 1963. So you see Clarence Gideon down there in the left-hand corner. He was charged in a Florida state court, so this is very important, of felony breaking and entering. Gideon requests the court appoint him a lawyer, but state law, Florida state law, only appointed attorneys to indigent, which means poor or needy defendants who couldn't afford to hire their own attorney, and capital cases only. Capital cases are those that involve murder. Because this didn't involve murder, according to Florida state law, if Clarence Gideon couldn't afford an attorney, tough, he had to represent himself. So Gideon did represent himself, and he was found guilty, and he argued that the reason he was found guilty was because he wasn't an attorney. He didn't know what the heck he was doing. So the case went to the Supreme Court because he believed the outcome would have been different if he had been provided legal counsel. So the key questions here is, well, the Sixth Amendment says that everybody has the right to an attorney in criminal cases. Does that extend to state cases? Because once again, when the Bill of Rights was written, these were supposed to be protections from and rights guaranteed from the national government, not state governments. This was a state case, not a federal case. So did the Sixth Amendment apply? And bringing this into play, once again, the 14th Amendment, we talked about it last time, the 14th Amendment made it a little more clear that, well, parts of the Bill of Rights do apply to state governments, and therefore they would apply to state criminal cases. So did the concept of selective incorporation, which is that idea that parts of amendments, mainly 1 through 8, apply to the states as well as to the national government, does that apply here? And you can see that in the 14th Amendment due process clause, that you can't take away life, liberty, or property without due process. And it specifically states that state governments cannot take away life, liberty, or property without due process of law, where the Sixth Amendment doesn't mention anything about state governments. So the ruling here, they ruled in favor of Gideon. They argue that the Sixth Amendment right to legal counsel must be provided to defendants in criminal cases who are unable to secure their own legal counsel, also known as indigent or poor or needy defendants, unless they waive this right. So if you can't afford counsel, yet you'd still like to defend yourself, you are welcome to. In this case, we know that Gideon specifically was requesting counsel. He did not want to defend himself. They also ruled that the due process clause of the 14th Amendment and this concept of selective incorporation, meaning parts of the Bill of Rights apply to state governments in addition to the national government, also made the Sixth Amendment applicable not only to federal government and federal cases, but to state governments and state cases as well. Just so you know, approximately at the time, about 2,000 prisoners were released in Florida based on this ruling. And in addition, Gideon was granted a new trial in which he was provided with defense at no cost. He could not afford it, and he was released. So McDonald versus Chicago is a relatively recent one. This was just in the last decade, 2010. So this case involved a very old ordinance. A Chicago ordinance dating back to 1982 had banned handguns within the city. So you cannot register a handgun in Chicago after 1982. So technically, if you were in possession of one and you were caught with one, that was illegal, that was a crime, and you could go to jail. An ordinance is simply a law done at the local level. It's another word for a law, but it's a law that would be passed by a town or a city rather than the state or national government. So there was a Chicago resident, he's down here at the bottom of the slide, Otis McDonald. He argued that he lived in a dangerous neighborhood and believed a shotgun would not be suitable for home defense. He was allowed to have a shotgun. He did not believe that would be enough to stop an armed invasion. A handgun would be much easier to do so. One of the reasons he argued this was his house and garage had been broken into on 5 different occasions by this point. So he had a reason to say, I live in a dangerous neighborhood, my house keeps getting broken into, and I'm afraid that at some point this is going to be an armed invasion where it could cost me my life. I need to be able to defend myself. He was sponsored by some groups, pro-Second Amendment rights groups, such as the Second Amendment Foundation was a big one. The key questions here: does the Second Amendment right to keep and bear arms for the purpose of self-defense apply to the states? Once again, this keeps coming up through selective incorporation of the 14th Amendment due process or privileges or immunities clause. So once again, the 14th Amendment has wording in there that says certain parts of the Bill of Rights specifically apply to state governments as well. They have to follow them. So the ruling here is the 14th Amendment and selective incorporation makes the Second Amendment right to keep and bear arms for the purpose of self-defense applicable to the states. So in other words, based on this ruling, and this is very controversial and it's still being debated today, when you read into this, according to the Second Amendment, the national government cannot restrict your right to bear arms. You can't make laws that will endanger that. And there's debate about exactly what type of laws would go so far as to restrict your Second Amendment rights. But according to McDonald versus Chicago, not even a state or local government can make any laws that restrict your rights. And we do see laws being made today that it could be argued they're restricting your rights when they start to talk about, for example, limiting the size of a magazine to only, let's say, 8 or 10 bullets, rather than having larger capacity magazines. People could argue, well, that's an infringement of my Second Amendment rights. It doesn't matter if the national or state government is doing that. According to McDonald versus Chicago, states cannot restrict our rights either to own weapons. One of the reasons they came up with this ruling in the Supreme Court was they said rights fundamental to the nation's scheme of ordered liberty or deeply rooted in this nation's history and tradition, including the right to self-defense, are applied to the states through the 14th Amendment. So the right to own weapons is such a deeply rooted tradition in the United States. In case you don't know, there's more guns in this country than people. There's 330 million people. I think they say something like there's over 400 million guns. That just goes to show that this is a very important part of the foundation of our country, and to take that away would be considered, I guess, disruptive to tradition. Our final case for today is going to be Brown versus Board of Education, 1954. So background about this case, dating back to 1896, there is a very important precedent that had been set in Plessy versus Ferguson, which had made segregation legal in the United States as long as it was separate but equal. So the defendant here, Homer Plessy, actually the plaintiff, had argued that because he was not allowed on a white train car, he thought that was a violation of his constitutional rights. Trains were segregated. He argued that everyone should be able to sit wherever they wanted on train cars in the railroad system. And the court had ruled in this case that that's not necessary. You can have segregation as long as a black facility and a white facility, for example, a train car, are separate, but as long as they are of equal quality and equal access. So as of the 1950s, based on this case, many school districts across the southern states were still segregated based on race, all dating back to this Plessy versus Ferguson Supreme Court decision. A little more background here. So in Topeka, Kansas, in 1951. Oliver Brown tried to send his daughter to the school closest to their home, an elementary school, but it was a segregated district. That school that was closest was an all-white school, and he argued that it was unfair that his daughter would have to be bused to a school that was much further away, that she should be able to go to whatever school she chose. So the key questions here: does segregation violate the Due Process Clause of the Fifth Amendment, which states, "Nor shall any person be deprived of life, liberty, or property without due process of law"? Liberty, freedom being very important here. The freedom to go where you want to go to school, especially if it's within your district and you're paying taxes potentially to go to that school. Does segregation violate the Equal Protection Clause of the 14th Amendment? Going back to selective incorporation once again. Nor shall any state deny any person within its jurisdiction the equal protection of the laws. All right, so if some students are allowed to go to a school that has better teachers, or we'll say more qualified teachers who might be paid more, there's more money going into that school system, you start to bring into this question of, is there equal protection under the laws? Is segregation truly separate but equal? So when this case reached the Supreme Court, they essentially overturned Plessy versus Ferguson. So this was the end, legally, the end of legal segregation in the United States. Although it took the South a while to kind of catch up, they still tried to keep segregation as much as possible, but eventually the federal government was able to step in and enforce the Brown versus Board of Education decision. So the ruling said that race-based school segregation violates the Equal Protection Clause of the 14th Amendment. Separate but equal educational facilities for racial minorities is inherently unequal because the whole point of segregation in the first place was there was this view that races were not equal. There was a view that whites were superior to blacks. So segregation in itself was inherently unequal, no matter how hard you wanted to argue that you could have separate but equal facilities. And then finally, segregation of public education based on race instilled a sense of inferiority that was detrimental to the education and personal growth of African American children. So if you are an African American child going to a segregated school, of course there's this dark cloud looming over you of, why am I here? Why am I in a separate school from white children? And everybody knew that there was this belief amongst certain white communities that whites were superior. So children kind of started to have this feeling ingrained into their heads, if you were African American, that you were of lesser value as a human being than a white child, which obviously is awful. And that's not something you want to plant in the children's heads.